Good afternoon. I'm talking to Carl Baldoff from the Ontario Chamber of Commerce. We're talking about some of the changes to Ontario labour and employment laws. So why don't you tell us a little bit about what is happening?
So the Government of Ontario has introduced Bill 148, which is the Fair Workplaces, Better Jobs Act. And this piece of legislation, which is currently making its way through the legislature, presently in first reading, is going to bring about tremendous change with the relationship between every employee and employer in the province of Ontario. And while much coverage of the legislation is focused on the minimum wage piece, the changes to the minimum wage are only one part of the overall changes that will come as a result of Bill 148. But let's start there. So presently in the province of Ontario, minimum wage is just over $11 an hour. And in the next 18 months, by January 1st, 2019, that will increase to $15 an hour, with increments occurring on January 1st, 2018. Well, first of all, this October by a minor amount, then January 1st, 2018, and finally $15 by January 1st, 2019. This is a significant change. As we look at international jurisdictions, we can't find any state or province or city that's moved this fast to $15 an hour. So, from an advocacy perspective, we're a little bit concerned about that pace of change, but it's certainly something that businesses have to be aware of. That's the minimum wage change. After that $15 an hour is introduced in January of 2019, the province will then revert to announcing every spring a change that roughly reflects the inflationary increase, and that will take effect every fall.
And what are employers telling you they think the impact of that will be?
So, employers recognize that an increase in input costs, and salaries is one of their most significant input costs, that rate is going to have to force them to make a number of decisions. First of all, they may choose to let go of individuals, or they may choose to just not hire individuals that they would have otherwise hired. I can't tell you how many employers I've spoken to have said, maybe I just won't hire that student next summer that I was going to, or maybe I might have to expedite somebody moving into retirement a little bit faster. Mm-hmm. Employers are also going to have to pass on some of those cost increases. So the cost of everyday goods and services we fully expect to increase. In fact, we hired an economics firm, a firm called CanCEA, the Canadian Centre for Economic Analysis, to take a look at the numbers. And what they've indicated is that, on average, families per year will have to pay will have to incur increased costs of up to $1,300 per family per year. So that's everyday goods and services going up in price. Yeah. But then businesses are also going to have to be faced with just paying people more, and they're going to have to figure out just how to swallow that costs. And so, when you cut it, overall, the minimum wage is going to add in total cost to the Ontario economy about $13 billion a year. But that's where we begin to look at what are some of the other costs that will come as a result of Bill 148. And so we know the legislation is going to provide for expansion of personal emergency leave.
And what is that?
So right now in the province of Ontario, if you're a business or an organization of over 50 people, you have to award 10 personal emergency leave days. With Bill 148, that expands to business sizes of all business sizes. So any business or organization will have to extend 10 personal emergency leave days to employees. So that's typically seen as something that would be incurred if you're sick or other grounds, including bereavement, etc. And so not only are they going to be extended 10 personal emergency leave days to all employees, but 2 of those personal emergency leave days will have to be paid. And so this is a major change. If you look across Canada, there's no other province that provides for 2 paid personal emergency leave days. And so here in Ontario, we're going to be a first to go in this area. But the other thing about personal emergency leave is that you have to recognize that it's not prorated. So for example, you could hire a summer student for 3 months. Mm-hmm. They could take off the last 2 weeks. You'd have to pay them 2 of those days. And the other thing about the change that's coming as a result of Bill 148 is that you won't have the recourse of asking for a doctor's note anymore. So you'll have to pay out these 2 days, give the student the full 2 weeks off, and you'll have no recourse to ask for a doctor's note. So a lot of businesses are concerned with what that change will mean for them, that they won't have recourse to understand. There is provision in Bill 148 for proof to be requested from an employer, but a doctor's note will no longer be appropriate for an employer to ask of an employee.
So what kind of proof would employees likely give then?
Well, this is where labor lawyers are scratching their heads to figure out how do we read into this legislation. I think that it's still it still remains to be seen when the rubber hits the road. You know, if you were able to show an Instagram picture of an employee, you know, swimming or surfboarding on a day that they were supposed to be sick, well, could you use that as evidence?
Yeah.
And it remains to be seen how that will unfold. But this is where a piece of legislation of this size, we're going to have to see how it unfolds legally, and much remains to be seen. So minimum wage change will have a significant cost impact for businesses. Mm-hmm. Personal emergency leave will have a significant cost impact for businesses. A third major change will be vacation pay. So presently in the province of Ontario, employers are mandated to pay 2 weeks paid vacation, and now employees that have been with an organization for more than 5 years will be awarded a third week of vacation. So that will add costs.
Okay. Are there any other changes in the Act that employers are talking about or concerned about or should be concerned about?
Sure. So some of the changes all the changes I focus on to this point are changes to the Employment Standards Act. Mm-hmm. But we have to remember that the Labor Relations Act will also see change as a result of Bill 148. And so the Labor Relations Act guides the certification process that an organization will go through. So a few key changes to the Labor Relations Act that are worth noting. The changes to in Bill 148 will extend card check certification to various sectoral types.
And what is that?
So card check certification, you know, we're all familiar with the process. If you want to certify, you have to go through a process whereby you demonstrate a desire by a certain amount of employees, and then a secret ballot vote happens. Mm-hmm. Card check certification, what happens is that if an employee group can demonstrate that 55% of employees have signed a card that they support a union, then that actually removes the need for a secret ballot voting process. Okay. And so, you know, from an advocacy perspective, we're a bit concerned about that because without a secret ballot process, the potential for coercion is there, the potential for very active employees who want to proceed with a union process, their ability to coerce their colleagues and to make some individuals within a company feel as though they'll be seen as scabs even before unionization occurs, that potential's there. So the government of Ontario has extended that to a few sectors, including temporary help agencies and a few other service sectors. Okay. The rationale for why those sectors and not others is not apparent. So that, from a labor relations perspective, this will add challenges. And one other change I'll mention is that as part of the certification process in Ontario, if an employee group is able to demonstrate that 40% of employees are interested in forming a union, then the employer is compelled to provide comprehensive employee information.
What kind of information?
Contact information primarily, okay. That will enable the employee group to get in touch with all of their colleagues. So that threshold in Bill 148 will be lowered from 40% to 20%. And so we're already hearing from labor lawyers that from a privacy perspective, that threshold is far too low. And so we anticipate that will be challenged shortly after the bill is shortly after the bill is passed. But suffice to say that the changes that will come to the Labor Relations Act, we believe will have the effect of expanding certification amongst many employee groups in the province.
What do you think the expected time frame for the legislation is? Where is it at right now, and when do you think this will actually reach the point of a final vote?
So the government introduced Bill 148 on January 1st of this year, which was also the last day of the legislative sitting of the spring session, and they spent all the summer conducting consultations. It's actually quite irregular for a piece of legislation to have committee consultations on first reading. Okay. But they conducted that, they made some minor amendments, and then with the legislative session getting underway in the fall, there will be a second reading, and we are unsure but suspect that they will go back to committee as part of second reading. Then the bill will have to have third reading and royal assent. So all we know is that the legislation will have to achieve royal assent by the end of the fall sitting, so that by January 1st, which is the intended deadline for the first phase of the new minimum wage to come into effect, it will have to have passed royal assent effectively before they go away for the holiday break. So typically the legislature sits until the end of the first week of December, mm-hmm. and if that's the case, we fully expect that it will be passed by the end of the first week of December.
So this is happening pretty quickly. What should employers be doing to get ready or in response to this?
So I guess there's two things. Well, three things. First of all, employers need to get educated about the scale of impact in Bill 148. The conversation we've had and the changes I've articulated are only 4 or 5 of the hundreds of changes that will come about in Bill 148. I cannot state enough the profound change that will come as a result of this legislation. It truly is a once-in-a-generation type of change that will have a major impact on businesses no matter what your business type or size. And so businesses need to become educated about what is in there and what it will mean for them. Secondly, I do think that there is a need for businesses, when they look at this and the cost implications that will come to them as a result of this, to contact their MPP and articulate if indeed they are concerned about the scale of new costs that will come as a result of these changes. We are hearing from a lot of businesses that they will not be able to deal with the costs easily, and will have to increase costs for consumers, and they will have to potentially let people go, and in some cases they will have to close shop completely. So, become educated. If you are concerned, communicate that to your MPP, but also your circle, your network, to help them understand the need for all of us to push back. But ultimately, I believe this government will proceed in some way with Bill 148. And so once that takes place, you will have to move very quickly, because once again, we expect this to pass sometime in November or December, and then take effect January 1st. To avoid having an unpleasant holiday season, I would advise you get out in front of the changes and be thinking about how are you going to adjust your 2018 business plan to accommodate these new input costs. Because we're already in an environment where electricity rates have risen. Next year we're expecting the CPP enhancement to be there. This will add a significant bag of new costs as well that you're going to have to contend with. And so giving consideration to how you can cut costs through a multitude of various tactics will be very important. And so, speaking with your legal advisors, speaking with your HR advisors, speaking with various consultants that you would rely upon to give consideration to that. A smart business will be thinking, how can I get in front of these changes and successfully accommodate to ensure that 2018, my plan is in place to deal with them easily.
Perfect. And if I'm an employer, where can I go to understand these changes and get something that's plain language where I can look at it and go, what does this mean and how do I prepare?
So, I would say you can go to the Ontario Legislative website that will have Bill 148. That won't be plain language though. Mm-hmm. And so you are going to need to rely upon professionals to translate that for you and to interpret it for you. It is true that the laws that come out are not written in a way that are truly accessible, and they are certainly not written in a way that's easily accessible to folks that are focused on making their business work day in and day out. I speak with many employers who don't have time to deal with this. They're just focused on making sure that the lights stay on and they're successful and they're providing good jobs and a good service or product. And so it is true that you should be relying upon the thoughtfulness of individuals who are in this every day to interpret it for you and to provide you with some help and guidance to understand how to successfully adjust to, as I say, a once-in-a-generation change. You can't get this wrong. Businesses can't afford to get this wrong. The scale of impact is far too significant. And so, become educated about the changes, communicate to elected officials around what this will mean for you, but ultimately you're going to have to adjust. And in so doing, you're going to want to rely upon the best advice that you can to get you there.
Okay. Well, thank you very much for your time today.
Great.
Very informative.
Thank you.
Thanks.